Well, welcome. Thank you all for being here. And thanks and many rounds of applause to Michael and Judd for gathering this group on this topic. I've said before that the Conn Law Center just provides us with one intellectual feast after another at the law school, so we are very grateful, and this is another. So the topic of this panel is executive, congressional, and judicial oversight of the administrative state, and we have a great topic near and dear to all of our hearts, as well as a terrific panel. You can read the full bios. They have lengthy and very distinguished careers. Let me just give you a couple of highlights, and I'll introduce them in the order in which they're going to present. Bill Simon is the Arthur Levitt Professor of Law at Columbia Law School. Bill was a member of the Stanford faculty until about 2003 when he decamped to the other coast, but we continue to try to claim him as one of our own as often as we can. Before going into law teaching, Bill practiced welfare and poverty law, and his work and his consulting continues to focus about lawyering in those areas. He teaches and writes about professional responsibility and legal ethics, complex litigation and remedies, as well as the origins and the complex evolution of the administrative state. In a body of work that I'm sure many of you know with Chuck Sable, Bill and Chuck have become some of the most trenchant observers of the emergence of new models of governance, public, private bureaucracies, federal, state bureaucracies, how they're changing. Similarly, he has been for a long time a very keen observer of the evolution of the profession and legal ethics. Joe Postell is here, right next to me, an assistant professor of political science at the University of Colorado in Colorado Springs. Joe teaches courses in political institutions, law school's on the brain here, sorry about that, American political thought and administrative law. His research focuses mostly on the administrative state and administrative law. He's edited 2 books, one called Rediscovering Political Economy and the other Toward an American Conservatism. And his current book, which I think he's going to talk maybe a little bit about today, is entitled Bureaucracy in America, the Administrative State and American Constitutionalism. The third panelist is Peter Shane, who is the Jacob E. Davis and Jacob E. Davis II Chair in Law at The Ohio State University's Moritz College of Law. Peter teaches and writes in administrative law with a special focus on the presidency and presidential power, and he teaches courses at the intersection also of law, democracy, and emerging new media. Peter's a prolific scholar. He was named by Ohio State in 2011 as a distinguished scholar. He's the author of well over 50 articles and book chapters. He's authored or co-authored 8 books. He's a frequent commentator on public law issues in newspapers and many other media. His latest books have focused on cybersecurity and the relationship between democracy and the rise of new forms of communication. Peter, I think you've had the most varied career of anyone I've ever met. I think you've held every job there is to hold if you're interested in public law. So Peter has held positions in various parts of the executive branch. He was the dean of the Pittsburgh School of Law. He's directed several different research centers at different schools, and he's engaged in a wide range of public service activities as well that touch on many of the topics he writes about. So it's a wonderful panel. And each of them are going to speak for 12 to 15 minutes or so, and we plan to end about 5:15. And I will turn it over to you, Bill. Thanks for being here.
Thanks. So if I can be permitted to oversimplify, there are 2 very broad ways in which courts hold administrative officials accountable. There is, first of all, what I call backward-looking accountability, in which the courts try to hold officials to their legislative mandate. And then there is what I call forward-looking accountability, in which the courts try to force administrative process to become transparent to political oversight. Now, administrative doctrine has been more preoccupied with the first than the second historically, but increasingly over time, the first type of accountability has been difficult for reasons that you've already heard something about, partly because even when legislation gets passed, it often doesn't provide much determinate direction. In fact, sometimes it doesn't do much more than identify a problem and authorize efforts to deal with the problem. Now, I mean, it's an interesting question, the extent to which The reasons for this trend are institutional, of the sort that the fact that it's harder for people to agree in legislatures on determinate directives, and on the sense to which the reasons are functional and have to do with the changing nature of the problems. So let me just, as an illustration of the latter phenomenon without assessing the relative influence of the two possible explanations, let me just say a few words about the trends in the regulatory process. And the thesis here is that in many areas, changes in industrial organization are driving changes in regulatory practice, and that judicial accountability doctrines are not well configured to address them. So the changes in industrial organization are related to, first, the increased pace of technological change, and second, specialization and fragmentation, so that activities that once might have been internalized within a single organization or a small number of them are now spread across many organizations that have to be coordinated. Now, the shift in regulatory strategy involves what you might call an intensified, supercharged version of management-based regulation. The initial idea of management-based regulation was that the regulators don't know as much as the firms, therefore they have to try to induce the firms to disclose the best practices. In the current situation, in many circumstances, neither the regulators nor the firms know for very long what the best practice is. So that the regulatory strategy has to be to organize continuing collaborative search for best practices among both the firms and the agencies. So it seems to me these remarks describe a variety of areas, including auto safety, energy extraction and production, food safety, and to a qualified extent, financial system regulation. And in these areas, regulation will typically involve two broad components. First of all, rolling rule error detection regimes that combine provisional planning with notification processes. So unexpected or adverse events get reported and subjected to root cause analysis to diagnose corrective actions that feed back to changes in the plans. The regulator's key job here is to set up and monitor frameworks for collaborative inquiry and problem solving. And then the second broad component is technology forcing. Regulators reinforce or create incentives for new technologies, and then when they're proven, they mandate them. Now, administrative law, by which I mean the law of judicial control of administrative action, is arguably not ideally configured to address these types of administrative regimes. First of all, with respect to rolling rule regimes, one problem here, of course, is that administrative law is focused on what the doctrine calls a rule. Now, what a rule means is a highly technical subject and a highly, in many circumstances, ambiguous subject, but rules tend to be both stable sets of norms that regulate discrete ranges of activities. So that means they tend to ignore both very comprehensive regimes and at the same time interstitial ongoing adjustments within those regimes. Well, rolling rule regime error detection systems are at the center of regulation in these areas, consist largely of these two spheres of activity that tend to be excluded or at least underemphasized. So the recent failures, for example, at General Motors over problems with the non-deployment of airbags arise from failures of exactly these processes. That is, the failures to share information across administrative units, both private and public, and the failure to induce timely corrective inquiry. And NHTSA's intervention has been largely devoted to supervising the repair of GM's error detection processes. Now, all of this, for better and worse, is pretty much outside the scope of conventional administrative law. And then second, with respect to technology forcing, conventional administrative law has a potential problem with technology forcing that has sometimes been actualized, and that largely arises from the front-loaded nature of judicial review. So there's a tendency for judicial review to be more intense at the enactment stage And then at the implementation or execution stage, there is the frequent availability of pre-enforcement review, which means that courts frequently assess administrative interventions at a time when there's little practical experience, and firms feel less pressure to comply as long as they have a chance to defeat them before enforcement is possible. And arguably, sometimes courts expect too much to be worked out in advance of implementation. So Jerry Mishaw and Jeffrey Harth's account of NHTSA, the National Highway Transportation Safety Agency's experience, illustrates these limitations. The court basically frustrated technology forcing by overly demanding upfront review. The agency reverts to its recall program in order to escape review entirely. Now, I just mentioned what seemed to be a couple of counterexamples of effective productive judicial intervention, or at least arguably productive judicial intervention, that's relevant to these two types of administrative activity that seem increasingly important, that is the rolling rule error detection and the technology forcing. So with respect to rolling rule error detection regimes, there's some interesting examples from the practice of particularly the district courts in institutional reform cases, civil rights cases seeking structural remedies for the reform of administrative practices. These cases have produced what I see as basically a parallel body of administrative law that applies mostly to highly dysfunctional state institutions. But they imply a conception of administration that is quite different from that of conventional administrative law, that emphasizes not rules, but planning, monitoring, continuous reassessment, and various mechanisms for discovering deviance or failure and diagnosing systemic consequence. So the scope of intervention tends to be fairly large in these cases, and maybe appropriately so, given pervasive dysfunction. But the premises about the nature of the administration in these cases actually might be appropriate to other types of agencies that are not pervasively dysfunctional, but that the courts could supervise with a much lighter touch, but with a view toward the non-rule administrative features of these regimes. And then with respect to technology forcing, I'll just say it's interesting that the most commonly cited examples of successful technology forcing recently are largely outside of the federal administrative law system. And that's the Montreal Protocol for ozone depleting substances and the California Air Resources Board. Both often cited, although not without controversy, as successful examples of technology forcing. Some federal courts have sometimes done better than they have with autos with technology forcing regimes, so they haven't always been fatal to effective efforts. But the key point here, and its intention with some doctrinal tendencies, is the court's willingness to allow processes of ongoing inquiry and correction to compensate for deficiencies in upfront information and elaboration.
You're finished.
I'm happy to stop.
No. You have a couple minutes left. I don't know what.
Can I reserve it till
for rebuttal?
Counsel, you may reserve your time for rebuttal.
Does that mean I get
Sorry about
5 more minutes?
Sorry about that, Philip.
I think my role as a political scientist on the panel, I guess, is to focus on Congress and the executive. And I think some of the things I'll say will pick up on a lot of the themes from the previous panel. That'll be specifically Congress, I think, will be the focus, congressional oversight of my remarks. The spirit of what I will say is informed by a little anecdote that a colleague recently told me. This colleague teaches courses on American political institutions, including the bureaucracy, and a student of his, a foreign exchange student, simply raised her hand and asked the question, just who is in charge around here in American politics? It's a simple question. Should get a simple answer. It's a question we ask very frequently, whether we're scholars or whether we're citizens. Who's in charge around here? And it turns out that the question is extremely difficult to answer. This question has become increasingly difficult to answer because, in part, of the rise of the administrative state. The administrative state does not fit neatly into the constitutional framework and further complicates this already difficult question. What I'll say in my brief time is to present the mixed empirical evidence for two propositions. Proposition 1 is that Congress controls the bureaucracy, and Proposition 2 is that the president controls the bureaucracy. For simplicity and time, I'll leave out the courts, although we know that they control the bureaucracy sometimes as well. The evidence for both propositions that I'll focus on is mixed because there are way too many variables in place in particular circumstances that affect each particular case, so that we can't treat that question, who's in charge around here, in such a categorical manner. After presenting the empirical evidence, I'll proceed to some normative conclusions, and those conclusions will be something like this. While some might regard this ambiguity about accountability in the administrative state as advantageous, I submit that the complexity and the ambiguity of bureaucratic accountability are serious threats to self-government. And ironically, some of the features of our constitutional system create problems in terms of accountability in the context of the modern administrative state. Therefore, it might be necessary to revisit some of those design mechanisms. That will come towards the end. First, let's consider Congress's powers over the bureaucracy. Many empirical studies in political science, particularly in the 1980s, worked very hard to prove that the administrative state is primarily responsible to Congress and not the executive. There are certain reasons why this hypothesis is plausible. First, Congress has the power of the purse, something we discussed in the last panel, and Congress authorizes agency programs and therefore can expand those programs or take away authority from the agencies. It stands to reason, therefore, that agencies would listen to the institution that controls the extent of their authority and their budgets. But consider, on the other hand, the president's authority over the administrative state. If agencies fit anywhere in our constitutional system, that place would seem to be in the executive branch, and the president is the chief executive. Presidents get to appoint the heads of agencies, get to fire the heads of many agencies, so it makes sense to hypothesize that agencies would listen to the executive, that the president would have the upper hand in oversight of the administrative state. There's also OIRA review, which seems like a game changer, although I would submit that it's not. And I'll leave that out of my remarks for brevity, but happy to talk about that in some Q&A afterwards. Okay, so both hypotheses can't be true at the same time and in the same respect. Congress can't control the administrative state and the president can't control the administrative state. They both can't be true. So what does the empirical evidence tell us? The short answer is that it is a very mixed bag. Studies have shown that agencies do respond to the preferences of Congress, but only under certain conditions. Studies have also shown that agencies respond to the president's preferences, but only under certain conditions. So what are the variables that affect which branch has the upper hand in oversight of the administrative state? The studies that I've looked at identify three variables, and I will posit a fourth variable. And control of the administrative state will shift between the two branches based on the existence or lack thereof of these variables. The first variable, again, sort of overlapping with the last panel discussion, is the existence of divided government. Though our system of separation of powers was designed, to paraphrase Madison, to connect the interest of the office holder with the constitutional rights of the office, political agreement frequently trumps this incentive. Studies have shown that Congress will delegate more power to the administrative state when government is united. This makes sense. Members of Congress trust that the president will carry out this new administrative program faithful to the wishes of members of Congress. In short, divided government means that Congress will typically seek to insulate power from the president's oversight. United government means Congress will happily delegate matters that the president can oversee. A second variable that affects the dynamics of oversight is the structure of Congress. And this is, I think, a particularly important one. One that really follows from the discussion of polarization. Scholarship in political science has traced the decentralization of power in Congress from the overthrow of the Speaker of the House of Representatives in 1910 to the present day. In short, the Speaker of the House controlled the agenda of Congress in the 19th century. Today, watch the Speaker of the House try to control the agenda, right? It doesn't work out too well. The power has become decentralized and has created power centers at the committee and the subcommittee level. These committees and subcommittees, and not the floor of Congress as a whole, are the primary contacts between the legislature and the administrative state. The legislators and the staffers on these committees gain expertise in the specific areas and programs managed by the agencies. And often these legislators have constituencies that are not reflective of the general wishes of the majority of the country as a whole. These committees use their powers over legislation and their powers over appropriation to extract favors from the agencies they oversee. The collective action problems of Congress as a whole don't apply in these dynamics because Congress as a whole doesn't need to act in order to force the agency to do something. Therefore, the more power is decentralized into committees and subcommittees in Congress, the more authority Congress will have to manage the administrative state. This will create networks of concentrated interests both at committees in Congress, interest groups, and in the administrative agencies as well. This process will transpire outside of the view of the president and the diffuse interest of the citizens as a whole. In political science, we call these things iron triangles, sub-governments that occur not in the whole Congress, but in just portions of that institution. A third variable that affects the dynamics of oversight is the power of presidential appointment. This is actually proven to be, in the empirical literature, the key variable that has allowed the president to get control of the administrative state. Removal is not necessarily as important as nomination. Especially since the Reagan administration, the tendency has been for presidents to nominate administrators with the same political views as those of the president. The team of rivals has become the team of the like-minded. However, these same studies have shown that gridlock in the legislature has prevented presidential appointments from going through at a regular pace. Presidents find it increasingly difficult to appoint like-minded administrators when those appointments fail to clear the Senate. Finally, though this has actually not received abundant treatment in the literature, I would posit a fourth variable that affects the dynamics of oversight. That variable is issue salience. When an issue is highly salient, the attention of the nation as a whole will be focused upon it. In that case, the attention of the whole nation makes this issue a priority for the president, who will intervene personally and forcefully in the process of formulating a policy response. These considerations will then force action out of the iron triangles in Congress and into a more popular, accountable forum. In these cases, the president will be able to direct implementation of policy, and Congress will be shut out. I think the financial crisis of 2008 and 2009 illustrates this dynamic very clearly. Congress was largely absent from the response to the financial crisis. The president directed essentially the response. What does all of this mean as a normative matter? We can summarize the dynamics of oversight in the following way. Both Congress and the president exercise some control over the administrative state. The extent of each branch's control varies according to various circumstances. Divided government, the internal structure of Congress, the political dynamics of appointments, and the salience of administrative policies will all affect the locus and the extent of oversight. Very little of this dynamic is understood by the average voter who sits around wondering, what is the answer to that fundamental question? Who is in charge around here? What this does is it facilitates the existence of an administrative state composed of experts but hidden from sustained public scrutiny, formulating policy without much concern for the input of the public. I think maybe the most significant empirical finding about oversight of the administrative process came from an article published by Ann O'Connell several years ago. Her study found that political influence accounts for very little change at all in the policy of administrative agencies. The variable she identifies as bureaucratic momentum is the primary explanatory variable in grasping what guides the powers and the behavior of the administrative state. In other words, they decide what to do, not the political branches. Now, there are obvious advantages to agency expertise. When politicians become involved in the administrative state, this expertise is potentially sacrificed. However, one of the critical principles of our system is that it is representative. By representative, the framers meant something very specific. In Madison's words, a Republican form of government requires frequent direct elections for those who make the laws. Brutus, his anti-federalist opponent, agreed, saying the same thing. This is Brutus. In a free republic, all laws are derived from the consent of the people by representatives chosen by them. End of the quote. The administrative state, when it interacts with certain features of our Constitution, undermines the basic representativeness of our political system. It is especially ironic we pride ourselves on eliminating indirect elections of lawmakers in the U.S. Senate, but then defend very indirect representation in the federal administration. The only thing demonstrated by the empirical evidence is that the administrative state does not respond neatly to anybody. Who is in charge around here? If scholars cannot answer that question, it is highly unlikely that citizens can do any better. We want elections to matter, but the main finding of all of our empirical studies is that they don't in the administrative process. So, to preserve this representativeness of our system, we might have to revisit certain critical components of our constitutional system. One obvious type of reform would be to give the president more control over the heads of independent regulatory commissions. This would ensure that they respond more quickly to the priorities of a new president elected by the nation as a whole. Perhaps eliminating the filibuster as an option for blocking administrative nominations would further render the administrative state accountable to the president. On the congressional side, reforms could do the same thing, namely give us a more accountable administrative state. Reforms that would undermine divided government and the fragmentation of congressional power would facilitate accountability. And here there are obvious overlaps with the previous panel. If we strengthen party leadership in the House, that would allow party leaders in Congress to advance a regulatory agenda rather than have the administrative state operate at the behest of these iron triangles. This would have the additional effect of facilitating bargaining and compromise between the legislative and executive branches regarding regulatory objectives. In other words, I think a more parliamentary system is a better approach to making the administrative state accountable. The problem that we face is that the administrative state floats in the political distance, removed from the people at large, but not from the concentrated interests that are heavily invested in how programs are administered. Elections are critical in setting the debate regarding fiscal policy, foreign policy, but regarding regulatory policy, the public doesn't really exercise a lot of influence. Ironically, then, it might be only by revisiting some of our constitutional structures that we can bring the administrative state back into politics.
Thanks, Joe. Peter?
Thank you, Liz. I also want to thank Mike for the invitation and for Judd for the wonderful arrangements and for Liz for lots of things, including joining the Michelle Merrill casebook and significantly improving the content thereof. What I want to talk, I'm going to go back to judicial oversight a bit and talk about the problems that are posed by judicial oversight of, it's actually not quite right to call it agency inaction because it's not always inaction, but agency non-enforcement or less than comprehensive enforcement or less than comprehensive implementation of the law. It seems obvious that the rule of law or accountable administration can be put at risk not only by agency initiatives that go beyond what are the agency's legal bounds, but also by agencies simply not doing their assigned tasks. This controversy has been raised, I suppose, most notably in recent weeks by the program of the Department of Homeland Security and its program and Secretary Johnson's memorandum on what's called deferred action for parents of Americans and legally resident aliens, which is abbreviated DAPA for short. DAPA always just, I don't have to say that title over and over again, so I'm just going to say DAPA whenever I'm referring to the deferred action program. And I want to say up front that I think, for what it's worth, that DAPA is substantively lawful, and I'm happy to talk about why I think so if that comes up. But that doesn't mean that these issues aren't serious, issues about whether the rule of law is put at risk by agency decisions to under-enforce or not enforce certain parts of the law. Indeed, I want to say that the issues are arguably yet more of concern because for a variety of reasons, courts aren't especially effective or even available overseers for recalcitrant agencies. And so it's worth considering whether there ought to be changes to enable courts to conduct more thorough review of agency decisions not to do things. But the argument that I want to make in my prepared remarks today is that the particular kind of review exemplified by what the district court judge did in the Southern District of Texas, Judge Hannon, which is procedural review demanding that there not be announced criteria of under-enforcement without notice and comment, from a rule of law point of view, is actually perverse and maybe counterproductive from sort of ordinary administrative law purposes. Agencies that possess significant discretion in setting their enforcement priorities, I would argue, should not be deterred by procedural hurdles from making those priorities public. So what might be called non-execution of the laws can take a variety of forms. We can imagine agencies engaged in a kind of policy-driven resistance to a legal mandate with which an administration disagrees. Probably the most well-known example in the literature comes from a case called Adams versus Richardson, in which HEW, former Department of Health, Education, and Welfare, under the Nixon administration, pretty much ignored the reports it was getting requiring enforcement of Title VI of the Civil Rights Act involving public school districts. But a much less well-publicized but sort of fascinating example happened in the mid-'70s. I mean, it seems startling to recall this in our current cultural moment, but not many decades ago, the immigration laws of the United States prohibited at least in formal terms, the immigration of gay men and lesbians. And the Public Health Service, which participated in the process of excluding them, simply announced in 1977 or 78 that we're just not going to do that anymore. And that led to a detailed story with the Department of Justice. Again, I'd be happy to explore if you're interested. So that's one possibility. Another possibility, of course, is just also policy-driven, demotion of some classes of enforcement targets that reflect an agency's limits of resources. The DAPA program is like that. The deferred action for the so-called dreamers, the children who arrived here without documentation because their parents brought them here. That's the DACA program. But also the 2013 guidance that the Department of Justice issued on enforcement of the marijuana laws in states where possession of marijuana was being legalized. That's another example. The Department of Justice has a very well-established policy called the Petite Policy, where it is the policy of the Department of Justice, except in civil rights crime cases, basically not to investigate criminal cases that could be subject to both state and federal enforcement if there has been a state trial. This is just, it reflects obviously values of federalism, but also the thought, why prosecute twice a certain set of actors when we don't even have enough resources to prosecute every deserving person once. A third kind of inaction would be the purposive exercise of discretion in individual cases, where there may not be broad criteria, but something comes to the agency's attention as a possible occasion for action, and all things considered, the agency decides not to do that. Heckler versus Cheney, which is the sort of iconic case on the presumption of agency discretion in these cases, is an example of this, where the FDA was asked to evaluate whether certain drugs were safe and effective for purposes of capital execution. And they said, we're just not going to do that. And then, of course, there's just a vast universe of roads that are not taken because they're not ever considered. I mean, the number of things agencies potentially could do and don't pretty much outnumbers the number of things that they could possibly do. So how are challenges to these kinds of inaction likely to occur? Well, it could be that the would-be beneficiary of a program that challenges programmatic non-enforcement goes to court to challenge that. It could be non-enforcement either because the agency disagrees with the policy or just because they're facing limited resources. So that's one kind of case. It could be that there's a putative beneficiary or somebody who wants to be the beneficiary of an agency decision to go after a particular case, not a category of cases, who wants to challenge that. There are cases where a party petitions an agency to make a rule, and the agency declines or says no, and then the party goes to court to challenge that agency decision. And when any of these things happen, of course, the parties can face a variety of challenges of standing, challenges of rightness potentially, challenges of identifying a final agency action. That's not always easy to nail down when an agency finally has decided not to do something. Heckler versus Cheney creates this presumption that quasi-prosecutorial decision-making that Congress vests an agency is presumptively committed to agency discretion. And of course, another challenge, even if all these procedural hurdles are overcome, is the court's limited ability to induce the action that the beneficiary wants. Massachusetts won Massachusetts versus EPA, and EPA, with not that much time on the clock going in the Bush administration, well, said fine. Okay, before we weren't going to regulate because we weren't even going to study this. Now we'll study this and not regulate until the clock runs out. And these matters can go on for years, and of course, presidencies don't go on forever. So this is an ongoing problem. So in Texas versus the United States, which is the recent case involving the Deferred Action Program, the trial judge found that the state of Texas at least had surmounted the standing and timing challenges. The standing was established based supposedly on the costs of the additional driver's licenses that would have to be issued. And the finality issues were solved by the embodiment of the program in 2 memoranda that the Department of Homeland Security had issued on November 20th, 2014, that set forth a set of enforcement priorities and directed the creation of an application program for deferred action. Because those memoranda set forth a program of deferred action, the court didn't regard what the agency had done as the kind of individualized discretion not to prosecute that would be presumptively not reviewable. And I think they were right about that. And I think this, the memoranda, did embody what the Administrative Procedure Act and I think common sense would call rules. But it's important to note that the court conceded that if the agency hadn't actually formalized those criteria in those memos, if they simply decided on an ad hoc basis to forego the removal of exactly the same number of undocumented immigrants as are protected by those criteria, the court wouldn't be able to review those decisions. That is, the presumption would be that each and every one of those millions of decisions would be beyond judicial review. And by the way, if the Department of Homeland Security and the Department of Justice had proceeded in that manner, that is, granting deferred action on a case-by-case ad hoc basis millions of times, then under existing Department of Justice rules, exactly that same number of beneficiaries could apply for work authorization and the other benefits for which they're entitled once they get deferred action. So this acknowledgement by the court implicitly raises the question, I think, would we, or for that matter, would Texas be better off if the Justice Department or Homeland Security exercised their discretion in an ad hoc way than they would be under the DAPA program? And I think it's pretty clear from a rule of law perspective, the answer is no. Now, I think I may have even had this argument at another one of Professor McConnell's programs with Richard Epstein, whether we have a rule of law at all. But I do believe that we aspire to a rule of law. My own conception of it is a kind of anti-formalist conception in which we measure the robustness of the rule of law according to whether we see government processes that are kind of cementing our allegiance to a set of normative commitments that are promoted through our institutional design. These include the idea that government action should be bounded by rules promulgated by legitimate institutions that are making the rules and constrain government behavior, that those rules be respectful of human rights, that government actors should obey the law, that they, in exercising the discretion that the law authorizes, that they should be able to, the government officials be able to justify their actions according to legal reasons, and that meaningful recourse should be available to citizens if they're injured by government action in violation of those requirements. I think the robustness with which government respects those values is likely to be proportional to the transparency with which government operates. By issuing his memoranda, Secretary Johnson made his department more directly accountable to both the general public and to congressional oversight and even to substantive review by courts than would have been the case if border agents had simply on their own decided, here are millions of people on a case-by-case basis to whom we're going to give deferred action. In a practical sense, the relative merits for Texas are also hard to discern. Yes, they will have to pay for the cost of driver's licenses over and above the cost of the fee they get for issuing the license, but they're also going to have a very large contribution to their economy. They're going to have reduced costs for law enforcement. Texas may be worried that the existence of the Deferred Action Program will so incentivize additional unlawful entry or people overstaying their visas as to create, new burdens. But this assumes that, the millions of people who might otherwise be thinking of entering the United States without documentation or overstaying their visas are not getting the same incentive effect by knowing that there are 11 million plus undocumented people in the United States of whom the department can only target 400,000 people a year given their budget. Whether the DAPA program actually adds to the incentive is just not clear. So if I'm right, if what we're talking about is, if I'm right, then so long as we're talking about what I'm calling the policy-driven demotion of some classes of enforcement target that reflects limitations of resources, and not simply a policy-driven resistance to a legal mandate with which the president disagrees, then I would argue from a rule of law point of view that agencies should be encouraged to make their priorities public, just as did the Department of Homeland Security. Contrary to Judge Hannon, the department did not waive its entitlement to exercise authority on a case-by-case basis. Steve Legomsky at Washington University has referred to the secretary's clear, careful, explicit, repeated commands to officers to make individualized, case-by-case discretionary judgments. The difference between what we have now and what we would otherwise have is the application process. It's hard to describe this as an abdication of law enforcement when there are still 400,000 people a year being deported, and it's not actually a change in anybody's legal status. If agencies know that publishing their criteria in this way will subject them to the burdens of an elaborate notice and comment process, they're likely to do it. Now, to be fair to Judge Hannon, the case law is not completely clear about the borderline between substantive rules that require public opportunities and policy statements that do not. The touchstone seems to be the degree to which an agency statement is binding, but there's a fight about whether we care about whether it's binding on the public, or is it enough that it just be binding on the agency itself. As the government argues, however, DAPA really is neither. It doesn't create new rights or obligations, and it doesn't bar immigration officers from exercising case-by-case discretionary judgment. It will actually reduce accountability, not increase it, if courts demand that agencies that are authorized to exercise case-by-case discretion are effectively told to keep their priorities tacit and obscure. So whether or not DAPA is lawful substantively, and I think the court should review that, reviewing it for lack of notice and comment was the wrong way to go.
Thank you, Peter. I want to first invite the panelists. Do you have any questions that you'd like to pose to each other?
Well, can I just agree with Peter about his analysis and suggest that this is an example of the kind of biases in administrative law that I was complaining about, right? First, you have a bias a bias against action in favor of inaction. So if the administrator doesn't want to explain her priorities, there's no duty to do so. If she wants to, then she has to assume all these burdens. So the net result is a huge deterrence to doing that. And I think there is, although I'm not an administrative law person, I think there is some evidence that agencies are increasingly resorting to tacit or low visibility modes of regulation because of the excessive burdens that are triggered. And so when I talk about the emphasis on rules as opposed to plans, it seems to me that the essence of responsible administration is that you have an explicit plan for the exercise of your discretion, which would be what's going on here. For the administrative law, it's just a question of, at some point, you're only going to be intensely regulated if you promulgate a rule, but at some point, if you trip the definition of rule, then you're going to be substituted to a uniform package of accountability that may be much more excessive than is appropriate.
That's really interesting. I hadn't made that connection, which is a very, I think, direct connection between what you were saying and what I've been thinking. And I'm now forgetting the name of the legal theorist, but somebody's written a book, I think, called Legality, that argument that law is about planning. And I think that fits. I guess the question that I want to ask Joe, and I'll just put it in the briefest way possible. Elections don't matter? Question mark. That I think would be a surprising conclusion to the parties who are regulated by the EPA, the NLRB, the Department of Energy. Elections don't matter.
Yeah, so
Question mark? Question mark?
so the argument I'm making is they certainly matter in fiscal policy. I mean, almost all elections are very heavily about fiscal policy and foreign policy. They tend to be at the very abstract level about regulation, right? So one party talks about less of it, maybe cites a few examples of regulations that they somehow will rescind. It's not clear how that's going to happen. But really, I mean, if you look at sort of the long-term growth of the administrative state, there would be certain points at which one might expect, 1980, 1994, for an election that brings in a wave of people with a different view of regulation to somehow change the volume, change the number of programs. And what we see, of course, is it tends to go in one way, regardless of what is decided in an election. So I think there are particular things at the margins that certainly are changed by elections, especially if they have high visibility. On the whole, I don't think the administrative state has gone in any other direction but one, regardless of electoral back and forth that's occurred politically.
So if I could just respond to that briefly, but then I also don't want to take up the audience's time. First of all, even certainly what you say is correct. I mean, President Reagan campaigned that he would get rid of 2 cabinet departments, and then somehow we wound up with 2 more. But that may reflect actually increasing public demand for services that the administrative state provides. It's just saying that all growth is in one policy, reflects a single policy direction, I think may not be right. And the other thing is, I think the Reagan administration did produce profound regulatory changes. So, look at antitrust policy, profoundly changed because of the Reagan Justice Department. So I just think the picture is a little more complicated.
I have the feeling that Peter Strauss has a question. So let's turn it over to the audience.
Comment question.
Comment question, yes.
So for Peter, this is the briefer question. There have been occasional suggestions in footnotes, perhaps from people that you wouldn't have expected them to come from, former heads of the Office of Legal Counsel, that one area where the courts could and should control the refusal to enforce is the situation in which the president simply decides this statute, or the Secretary of Agriculture decides, this statute is one that I'm just not having anything to do with, and it will not be enforced. And so the question is whether that's at all a possible division point. I think you know that I'm in entire agreement with you on the issue of having and publicizing enforcement priorities. My favorite example is the website of the Occupational Safety and Health Administration, which is a chronically underfunded agency and which every year posts on its website its description of what its enforcement priorities are going to be. Unfortunately, they tell people who have 2 times the ordinary incidence of workplace injury in their factories that they're not likely to run into OSHA. But that's Congress's fault, right? That now this goes to Professor Postell. That goes back to how much money is Congress willing to provide to an agency to do the work that the agency is supposed to do. Professor Postell, I want to ask you to re-examine your decision to leave, you said OIRA, but I will say White House staff generally, the czars as well as OIRA, out of the picture, and for a couple of reasons. One of them, in describing congressional oversight, you're describing a process which is more or less continuous. Whereas for the president, it's only the point of appointment of the head of the agency, in the way in which you presented it. It's only the point of appointment of the head of the agency, with maybe some threat of removal hanging over his or her head, and particularly salient issues. And it seems to me that the reality of the situation is that the president's or the White House's connection to the agencies is much more substantial than that. And then the second part of the question / observation is drawing on a piece that David Barron wrote some years ago, that the increasing politicization of the bureaucracy, the increasing size of the number of people who work in agencies who are politically appointed or politically controlled, as distinct from what it might have been 30 years ago, is also a major source of effective presidential oversight control of what goes on in agencies, and whether they're so-called independent agencies or whether they're OSHA and the EPA, seems to me not much to matter.
Peter, you want to start? Or
Sure.
Joe?
I do think that the line you suggested of where the refusal to enforce is just based on, I don't like that statute, I think is reviewable, and that's an unacceptable basis for non-enforcement. That distinction, there's a case, a Third Circuit case, I think from the late 60s or early 70s, called Pennsylvania versus Lynn, that involved the Nixon administration suspending a couple of programs of mortgage relief for low-income housing. And the court drew that distinction. The court said, okay, let's look at the reasons. Oh, it looks like the administration has said Congress wants to accomplish certain purposes. We have determined that those purposes would actually be undermined if we did the program exactly as it's been done. So the court said, now we look at the statute. Was the agency given the discretion to correct the statutory error? We find that it was, and because this was not just policy disagreement, but in fact a fact-based conclusion, that's all fine. The example that I mentioned in the mid-70s, which I had occasion to witness as a member of the Office of Legal Counsel at the time, was one in which the Public Health Service simply said, we just find it abominable that we would be required to certify homosexual persons as having what the statute called psychopathic personality, and we refused to do it. And the Justice Department was anxious about that, not because there was any disagreement about its unseemliness, but because having to say, we're just going to ignore this part of the statute seemed like a very bad precedent. The department, in negotiation with HEW and INS all together, came up with enforcement criteria that basically said, we're not going to wash our hands of this altogether, but the criteria were such that the only people who would ever actually be caught in this web would be a voluntary test case. But that was publicized. It was done through a press release. And I think that was appropriate. When we asked the Department of HEW, weren't they anxious about just saying we're going to wash our hands of this law? The then General Counsel said, oh, yeah, there are laws we don't enforce all the time. I must say I found that a very unsettling answer.
Joe, do you want to?
Sure, yeah. So the two comments actually sort of point in different directions, right? One into the executive office of the president and the oversight role that plays in how that strengthens the president's position with regard to oversight. And then the other, which is the increase in the number of political appointees in the regular departments and agencies. The existence of both strategies in some ways indicates the insufficiency of at least one of them. And so the rise of the executive office of the president over the last several decades suggests that presidents have believed they were unable to get the influence in the administrative state that they wanted through the regular appointment process. This is the great story of the Nixon presidency. Reagan, of course, was much more successful, but even recent stories about the current president, there was a story, extensive story, Locked in the Cabinet, which basically chronicled how cabinet secretaries in the current administration essentially they've been circumvented by the executive office of the president. So in a way, I mean, this just points to the different avenues that are available, but how neither seems to work reliably and consistently, or at least the development of both strategies suggests that possibility.
There's also a suggestion out there that, in fact, it serves the White House to appoint into the agencies people who will be relatively enthusiastic about what they are being appointed to do, while keeping within the White House, whether under the name of czars or in Elvira or wherever, people who are more finely attuned to what the president's personal priorities are. And those folks operate under a cloak of considerable secrecy to moderate what happens out in the agency.
Okay, so there's something like soft administrative power going on here, and this is what makes it very hard to quantify and measure. So discussions of the OIRA impact, which obviously is not all that EOP is doing, suggest that, yeah, you can point to many rules that are rescinded once they're sent over to OIRA. On the other hand, it's not quite clear whether OIRA has the legal authority to require an agency to rescind a rule. And we know that obviously independent regulatory commissions don't have to send their major rules over to OIRA as well. It's done by executive order, so it's not even clear whether Congress actually sanctions this or not. So there's considerable ambiguity about how that oversight process works. It seems to defy the sort of legal channels that we'd like to see, and it's much more sort of influence, it's like I said, soft in how it exerts its influence.
I think this gentleman was next.
Hi, I wanted to address Professor Postell's question about who is in charge around here. So it seems to me that when Congress identifies that they believe an agency is misbehaving, and by extension the president perhaps, the most straightforward way for them to express their displeasure with this and try to get control of the situation is actually to pass a bill, as opposed to any other sort of oversight mechanisms. And that in that situation, there's sort of a fox watching the hen house going on, where the president has veto power over these bills, right? So you pass a bill that says we disapprove of what this agency is doing, and it goes to the president's desk, and the president says, yeah, you can't tell me what to do, and he vetoes the bill. And then, of course, the threshold for overriding a veto is very high. We really rarely see those. So I was wondering if the panel could comment on the potential of lowering the threshold for congressional veto as a way of actually sort of restoring more balance, more power to Congress vis-a-vis the president with respect to the administrative state.
Yeah. That would fit with the concerns behind that suggestion, fit with the concerns I'm voicing about how divided government and the general fragmentation of power, as Professor Pildes has pointed out, prevents meaningful sort of coordination and meaningful oversight. Obviously, to lower the veto threshold, you're talking about a constitutional amendment. Other kinds of measures would require a constitutional amendment. Getting rid of divided government would require one, because we have a staggered election system that produces divided government because of off-year election cycles and all of that. But there's a way of getting some of these things without a constitutional amendment, and I just think that that solution is very, very strong political parties within our system. So have the parties nominate the candidates. The candidates being nominated by the party leaders would be beholden to those party leaders, and therefore the party leadership would have ample means to coordinate between the two branches. So that would be a way of trying to achieve the same effects without the more radical measures like changing the election laws as they're set in the Constitution, or the veto override, or those kinds of things.
Of course, Congress attempted over a period of decades to do the very kind of thing you're suggesting by putting into statutes this legislative veto provision that would enable them, without going back to the president, to disapprove and nullify agency regulations. President Reagan in 1980 ran on a platform in which he said if he got to be president, he'd love to see the legislative veto, and because he thought that would be an appropriate limitation on the regulatory state. And then, of course, he got to be president, and he was persuaded by a lawyer named Ted Olson, who was head of the Office of Legal Counsel and went on to other high-profile activities, that this was unconstitutional. The executive branch, when the legislative veto was challenged in court, confessed error. Congress tried to defend the constitutionality of the veto in the Supreme Court, and it was unsuccessful. And I think there's not much hope of it, in part because, again, I want to go back to what I was saying to Professor Postell before. I think although conservatives and liberals may differ from what they want from government, the agenda, everybody's agenda is for some kind of government action. And if Congress doesn't have the capacity to make changes in the world, that is going to invite executive initiative within the bounds of whatever legislative discretion they already have. There's a book called, I think it's called Prometheus Unbound. It's that the Eric Posner, Adrian Vermeule book, basically arguing the executive unbound. That we have executive-driven government. It's not what Madison envisioned, and we should just get over it. It's great. We don't have tyranny. They actually celebrate the kind of pro-executive theorizing of Carl Schmitt, a political theorist I wouldn't have thought we would want to resuscitate. But I've had arguments with them about the thesis. But I think the hardest point for me to counter, because I'm not sympathetic to the anti-rule of law point of view, is when I say when I make this sort of Peter Schuck points about the importance occasionally of gridlock, and one person's gridlock is another person's careful deliberation, they say there's just no constituency for that. What people want is action. They differ about what kind of action they want, but the reason we have continuously growing state is because people want action.
Hi.
Got two questions. One relates to Peter's point about giving agencies bad incentives not to issue documents about their enforcement priorities. And there are a lot of administrative lawyers in the room, and so both you and they can speak to this. But isn't there a certain fixity once you issue the rule such that the new administration just can't come in and abandon the rule without going through some process? And therefore there's perhaps some incentive to going through that process. It's not just to satisfy the judge. And so instead of just looking at it as a cost, maybe there's a benefit. The president says his policy can be whisked away with a pen after he leaves office, but in fact, maybe that's not true if he has to go through the rulemaking process. And the second question was brought about by Peter Strauss's question and your agreement with him. I wonder, in a world where we have lots of laws and lots of scofflaws, do we really think that if there's one person who violated a law that seems to the prosecutors inconsequential, that the prosecutor has to devote resources to the enforcement of that law just to show that he or she has enforced every single law? It just seems odd to me to think that where Congress hasn't specified or the lawmaker hasn't specified, we want to make sure that you are enforcing every single law at least a little bit. And if that's true, there's nothing wrong with not enforcing a particular law if you don't have enough resources and you have other priorities and Congress hasn't specified what your priorities ought to be.
I guess that's also directed to me.
Yes. I think you agree with that second point. So.
Right, yeah, I do agree with the second point, although, again, and these things are hard to monitor, but it's one thing, yes, there are laws that aren't being enforced because they're of low priority. But in the example that I mentioned that was worrisome, when the general counsel at HEW was saying there are lots of laws we don't enforce, he was counting within that kind of the discretion simply not to enforce a law because he didn't like it. And I think, for example, the Department of Education now funds bilingual education. Should a president who believes that basically immersion learning in English is the only way to go be able to say, I'm just not going to do it anymore? I find that a very troubling scenario. So I think it's the reason that counts, to my mind, for why a law is not being enforced. I do think, as you raise this interesting point. If what I'm calling a guidance document is actually a substantive rule and it's adopted by notice and comment rulemaking, then it would seem to follow that the rescission of that rule would have to follow notice and comment rulemaking too. It would increase its stickiness, as you say. But now I guess I would say in terms of having a responsive administrative state, I'm not sure we should want administrations to try to solidify their enforcement preferences beyond their term. Maybe that's actually another reason to prefer the more discretion-preserving mode that Secretary Johnson tried to pursue.
Two things, sort of. One is, it seems to me that the Supreme Court has generally said anything an administrative group wants to do which is close to the law is okay. One could go the other way, and they could turn around and say, unless the law absolutely positively requires this, we will not allow the administrative group to go beyond that. Sort of, you're innocent until the law enabling this really proves you must have that action. The other one on the law, rules. Couldn't you argue that the non-enforcement of laws could be, even if it's not a rule, could be pushed up by disparate impact? That if you discover that 90% of the Dreamers aren't enforced, then the department that is enforcing that must prove that it's not just an impact, even though it's hidden underneath a non-rule.
It's a hypothetically plausible doctrine, but it's not where the law is now, and I don't think the court is moving in that direction. Because I don't think the court would want to kind of cement, what are the important enforcement priorities of a particular time based upon, just a transient administration's set of priorities.
I want to build on Sai's question for Peter, and then I'll have a question for Joe just to even it out. So I agree that one thing to think about in design, the question of whether policy statements and guidance documents should be reviewable for notice and comment depends in part on the benefits and the costs of imposing judicial review. And I appreciate your sort of the reason giving that you're talking about, but I also took your explanation of why you didn't think it was the right outcome in this case to involve some careful assessment of how the regulatory program would play out, given the provision of notice to regulated parties or to the public as a whole. And I guess the question I have is, if you rely solely on reason giving, right, then the problem you get is agencies will always say it's resource allocation. And then you're back to the earlier suggestion, do you go beneath that, which has issues that I'll get to in a second, I think. Because the other option, of course, is to try and have the courts do a careful evaluation. Does a policy statement advance the goals of the statute, where we want to step in because we think it's problematic? And now we're starting to get a very complicated process, a hard to predict process for whether we should have judicial review for notice and comment. And then that's it from the argument you're giving just as bad from the agency's perspective as having judicial review, because if they can't predict it, they'll just be risk averse and they'll always avoid giving the policy statements in general. So I guess if we're not going to use a simple tool like reason giving that seems easily evaded, how do we avoid getting either allowing complete abdication when it happens or getting into the mess that we've talked about in general in administrative law of courts having fuzzy standards that become effectively imposing judicial review? And the question to Joe that is, I think, builds on Peter's question about how do we know that this just isn't what people want, is it seems to me that a comparative analysis here would be very helpful. We have a lot of different comparable economies and political systems that have parliamentary systems, that have complex bureaucracies, including one just to the north of us. And it would be interesting, there's difficulties of measurement here, of trying to get a sense of whether the more parliamentary system has produced better outcomes, however you want to define in terms of accountability.
Sure. So, very good questions. Yes, agencies, an agency asked why it's doing less of something than others might prefer, may always claim resource limitations. But it's important to note in this example, and again, different programs may proceed differently, that wasn't the sole rationale. In fact, at the same time that the program was announced, the Department of Justice released the Office of Legal Counsel opinion that signed off on the program, which stated a series of what the department took to be principles limiting the agency's discretion. One was that it had the power to set its resource agenda, but there were other limiting policies. And what's often been under-publicized, Judge Hannon's opinion says, if we accept the department's rationale, there's no limit to the department's authority to have deferred action. Not only did OLC state a limiting principle, but they imposed that limiting principle to prevent the department from going further than they did, because the department had also asked the Department of Justice whether it would be permissible basically to give deferred action to all the parents of the kids who were protected by the earlier deferred action program. And the department said no. So I don't think it's quite fair to say that the agencies are only going to rely on resource limitation. I think if they are pressed to judicial review, they would have to give other additional reasons. And I do think you're right that the unpredictability of the outcome would further deter the publication of those priorities.
I think with regard to the comparative analysis, I think it's an excellent idea. That work would build on some studies that have come out recently that show, in fact, I'm thinking of Frank Buckley's recent book where he says parliamentary systems do a better job of checking executive power than our separation of power system. My argument would be I'd be looking for something a little different, which is to say, I'd be looking for accountability, not checking. And that would be the ironic thing, is that our separation of power system is designed to check power, yet it's when you throw it in the mix with an administrative state, it actually performs the opposite effect, as I think some folks were saying in the previous panel. The inability of the legislature to act actually facilitates an expansive executive. And so the argument that I would be looking for is not so much a checking one as an accountability one. But it stands to reason, I think it's a reasonable hypothesis to say, after an election is held in the parliamentary system and they appoint all of the ministers into the executive branch, the party that wins the majority in the legislature, it stands to reason that that would promote a sort of response in administrative policy that would follow from the election that just transpired to a much greater extent than the system we have, where we're not quite sure what an election meant for what administrative policy should look like the next day.
I think, Zach, I think you were next, and then Mark.
I have another question for Professor Shane, which is, it seems to me that one of the many puzzles about enforcement discretion as a category of administrative action is that transparency, which I agree is normally a sort of rule of law value or mechanism of accountability, is actually frequently counterproductive in the enforcement context. In other words, if what the agency should be doing is enforcing the law, and particularly doing so with limited resources, one of the best ways it can do that is by keeping its priorities secret. And so just to give a simple example, the IRS, for example, has internal audit criteria that it uses to figure out who to audit, but it quite properly keeps those secret because otherwise everyone would use them to evade, to conceal tax violations. So what I'm wondering is, how do we distinguish situations like that where it seems completely contrary to the agency's mission to be transparent about what it's doing, from situations where anyone has suggested it's actually valuable?
A great question. I would have expected Zach Price to have a great question about discretionary non-enforcement. I think, it does depend a lot. First of all, there may be a distinction as a matter of policy judgment. I'm not sure that there's going to be a legally enforceable distinction. But I think, agencies may differ in their own assessment of the relative costs and benefits of transparency. I'm thinking, as I said, in the case of the immigration programs, I think DHS quite logically could have made the determination, the picture that appears to people who are not in the United States about their likelihood of being allowed to stay or not is not going to be much affected by the precise terms of this program. It goes into effect for people who have been here for at least 10 years, I think, and so on and so forth. I mean, what potential undocumented immigrants or overstayers of visas are thinking is, again, we know they have enough money to get rid of 400,000 people a year, but there are 11 million people, and the possibility of being removed, if you get out of the vicinity of the border, goes hugely down. Most of the 400,000 are apprehended and removed pretty close to entry. So I think they could rationally assume there's no point to publicizing it. There was a case that I was involved in the 1980s. The Department of, people may or may not recall, that one response to the Soviet invasion of Afghanistan was President Carter's decision to reinstitute draft registration, not the actual draft. But there were a number of draft resistors who wrote to the government and basically said, I disapprove of this policy. Here's my name, here's my address. I'm not hiding from you, but I'm not going to put it on the government form. And the government made a decision that the only people that they would prosecute would be the people who wrote into the government saying we're moral protesters. And we were able to unearth a memo in which somebody in the Justice Department said, we have to go after these people because if people can observe that there are people who are getting away with this will accelerate non-compliance. But we can't announce this because there are a gazillion people not registering, and we're never going to find them. So that kind of substantiates the point. But I'm not sure that there's I can't think aloud a way to make this determination in a kind of legally enforceable way.
So we're gonna stop about 5. I said 5:15, but I think actually 5 is the end. But Mark, please go ahead, and then Peter Schuck, I know you have a question.
So excuse me. This is a sort of quasi-cynical comment about reform proposals, which is in some ways directed to Professor Postell and Bill Simon's position, but also to other things that we heard earlier and that I'm sure we are going to hear tomorrow. So here's the observation. People have reform proposals which, if implemented, might address these issues. But the question for me, the single version, is given the existing structure of government, which has created the problems that these reform proposals are supposed to address, how is it that these proposals are going to get adopted? Like empowering party leaders to select candidates is the one that you want. And so here are 3 candidates. One is the exogenous shock, which in current California terms, I would say that's the pray for rain solution. Okay, if rain comes, it's fine. The other I take from some of the Sable-Simon work, which is you reach a point where everybody agrees that something needs to be done, and everybody agrees that everything that we've tried so far hasn't worked. Okay, those are pretty stringent conditions. Okay? The third is we do have an action-forcing institution in the government, which is the Supreme Court. So the Supreme Court could say, like, 2 things that are sort of obvious at this point. We are going to take the non-delegation doctrine seriously, so you can't delegate it off to the agencies. Or I don't quite understand why the campaign has taken this form, but we should overrule Auer, and then after the court should overrule Auer, and then after it overrules Auer, it should overrule Chevron. I don't understand why Auer has become the big deal in this issue. Chevron's the real target. But then you have to ask, well, what would it take to get a Supreme Court that would do these kinds of things, right? And then the sort of hopeful version of this is, well, if you got a court that was willing to do that, you might not have to. If the conditions were such that you could get a court to do that, you might not have to do the structure would already have changed anyway. So you actually don't need it to do it. Okay, so so how do you get there is sort of the bottom line question.
Mr. Governance, do you want to?
Well,
Bill.
So one question, you know, I had this for Rick. I was wondering if he had another table that would tell us, another chart that would plot divisiveness amongst Congresspeople against the corresponding views of the citizenry generally, and would explore the possibility that the partisanship is higher among the elites than among the citizenry. And then the question would be, okay, we have to have reform that transmits the will of the citizenry more effectively to representatives. Another answer is that maybe even under the current institutional regime, we overestimate the degree of divisiveness. So, you know, if you look at some of these institutional reform cases, for example, that, you know, I've looked at recently, you find that, you know, once you define the problems concretely enough, you can actually generate quite a bit of agreement about what would constitute a problem and what would constitute success. So, like child welfare, prison reform, police reform, water resource management. I mean, there were all cases in which there were institutional dysfunctions that arise either from the fact that certain stakeholders were not heard, or because the system was too fragmented. The stakeholders who had to get together were too fragmented, and the courts intervened in a way that actually did remedy these problems. I'm not proposing this as a solution to all the problems that have been mentioned today, but I just pose it. A good example, by the way, is Charles Harr's book about the cleanup of Boston Harbor, which is largely the courts took over in a system where the political function didn't work. The courts actually took over and made it work in a way that almost universally is conceded to make it work. So the question is whether, in fact, if there isn't, in fact, more agreement or potential agreement if the problems were reframed than has been suggested.
Before actually responding, I might just interject my own view based on some limited observation about the partisanship in Congress versus the citizenry. My look at the data suggests that the problem is not that members of Congress are not representative of their constituents' views, but that they are very representative of their constituents' views. That maybe the American people as a whole are not incredibly polarized, but when you sort them into districts, and those districts become increasingly homogenous, and each district chooses one representative, then you get the sort of thing that's happening now. But with regard to the question, so of the three scenarios laid out, I think two, I suppose, more open to thinking that scenario 2 is starting to transpire, which is the way you describe it, that there is a major problem. Everyone agrees that there is a major problem, and everyone agrees that what we're doing now isn't working. I think that's starting to actually happen with regards to gridlock, polarization, and the inability of our political system to react quickly. The difficulty is that you have to add to that second scenario an additional factor, which is then there's agreement about what ought to be done in place of what we are currently doing. And I think that's where the real problem is. Most people think that the parties are driving the polarization that's happening as opposed to that they might be the solution to the polarization that's transpired because of this sorting that's gone on and just the nature of our system choosing one person out of these local districts and then asking them all to come together and make laws for the common good.
Peter Shaw.
Let me precede my question by saying that I've been advocating for at least 15 years a more generous amnesty than the president ordered on policy grounds. So I completely agree with that. But I think you would agree that context matters in assessing whether a particular exercise of presidential authority is valid. And let me give you 5 contextual considerations here. First, with regard to the immigration issue. First, Congress has repeatedly refused to grant the relief that from deportation that the president has ordered. Secondly, the statute itself carefully delineates when such waivers can be from deportation can be granted. Third, the president himself stated that he lacks the authority to do this. Fourth, the discretion is being exercise to grant relief not to a person here or a person there, but to 5.5 million people. That seems to me to be a very, very different kettle of fish than the one you described. And then finally, not only is the president granting relief from deportation, but he's also granting a set of entitlements that Congress has expressly refused to grant. That is to say, work authorization and tax credits where they would otherwise be entitled to. Doesn't that matter?
Yes, I just view them quite differently. The entitlements that you're referring to do not arise from the November order. They arise from substantive rules that were adopted pursuant to notice and comment years earlier that apply to people who receive deferred action. Yes, a large number of people will benefit by them, which means arguably that this is, it establishes that this is going to have an impact beyond what would likely happen just by the number of individuals who on a case-by-case basis come to the government's attention. But by the same time, they're likely to be handled more fairly, more consistently, and the benefits that come to the state of Texas from having a deferred action program that gets people into higher paying jobs and tax paying and all of that good stuff will also be more numerous. The president made in a casual interview the statement that he didn't have the authority to change the law. He probably meant to say, I didn't mean to change the policy, but in any event, the casual remark of the president has no legal bearing on this, and beyond that, they haven't changed the law. That is, nobody's legal status is actually changed by virtue of having deferred action. The documents are absolutely clear about this. Congress repeatedly has, they haven't signed off on this deferred action program, to be sure, but they have signed off on many others. The George H.W. Bush program affected a smaller number of people, but probably the same percentage of undocumented aliens who were present in the country at that time. And Congress in the Homeland Security Act of 2002 gave the Secretary of Homeland Security express statutory authority to set enforcement priorities. The Department of Justice had, and now the Department of Homeland Security has, express statutory authority to make rules to carry out all provisions of the Act, including, I take it, the authority to set enforcement priorities, which is expressed in the statute. The legal context seems to me to be quite hospitable to what the president has done.
We'll have to discuss this at dinner.
That's right. Well, I think Joel Samuelson's standing in for Michael, maybe. We'll have the last question.
He picked up on a lot of the points. I just want to make sure we're all on the same page in terms of what Judge Hannon actually said in his decision, which I have read. That decision is not about whether or not the Obama administration has prosecutorial discretion. It is the conferral of benefits that is the root of his decision, is it not?
Well, I have said in a number of venues that yes, that and a number of other mistaken premises goes to his opinion. It is, I have to say, I'm sympathetic to the idea that Texas should be able to get substantive review here. I'm not opposed to that. The opinion, which I've also read, is usually overwritten, and at parts, Judge Hannon, although he says, I'm just doing a procedural thing here, makes absolutely clear his position, often in, wildly intemperate terms. At one point, he tries to show that the president is engaged in lawmaking by saying, well, the president describes this as an initiative, and when I look in Black's Law Dictionary, initiative means, the kind of thing that the people of a state vote upon to adopt law instead of the legislature. So this must be lawmaking. That's got to be the best non sequitur in the history of jurisprudence.
The OLC memo specifically does talk about the conferral of work authorizations right in the November 20th memo. It's right there.
I'm saying, and they say that that the conferral of work authorization happens under pre-existing rules, which they cite in the opinion.
Well, I'd ask you to think about one thing, and we are out of time, but I'd ask you to think about this and maybe talk about it another time. Could the head of the IRS in a future administration say that he doesn't believe that anybody should pay more than 30% of their total income and taxes. And the IRS, after all, does not have the budget to go after everybody who doesn't pay enough in taxes or doesn't pay the statutory rate. And therefore, they're going to give 5 million taxpayers get out of audit free cards because they've paid 30% or more of their income in federal income tax. And how can you distinguish that situation from this situation where you have an agency basically not only declining to prosecute because of limited resource, but actually giving an affirmative benefit that is directly contrary to what the statute, what Congress has said. We can talk about that another time.
Okay, briefly I will say, this policy is not what confers the benefit. Another rule is what confers the benefit. The department has not adopted the policy pursuant to a stance that the law is in any way inappropriate as it now stands. So for the IRS to say we're not doing what you suggest because we don't like the law would be a completely different case. And I find it very odd when the department is actually removing from the United States more people than any administration has removed, to talk about that as an abdication of the law, as many people have. I mean, if Congress, to remove everyone from the United States who is now without documentation at the DHS current budget would require 20 years, assuming that no other person came across the border unlawfully or remained beyond their visa.
Congress has also said specifically in the statute how it is that somebody who is the parent of a United States citizen gets the right to have lawful presence in the United States, and they have to actually leave the country and stay out of the country for 10 years, right? That's right in the decision.
Which is why it's very clear, and this will be my last comment.
Well, I think, Peter, you do get the last word. You're on the panel, so
Okay.
you can have the last sentence
The
here.
policy makes it clear that this does not establish lawful presence. First of all, it's not unlawful to be present in the United States without undocumentation. This doesn't change the status of this. And again, I just want to say that there is no change in the legal status of any undocumented person by virtue of the operation of the document.
All right. We've started a conversation that's going to continue. Let's thank the panel.